In this section of the video, we're going to start talking, we're going to cover the 4th through 8th Amendments. These are the rights of the criminally accused. 4th Amendment, search and seizure. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what this says is that for a search to happen, for an arrest to happen, we have to have a court-issued warrant before the search or before the arrest is made. So for a legal search, the court has to sign off on a warrant, whether it be a search, whether it be an arrest. Now, is a warrant always required? No, the warrant isn't. There is something out there called probable cause, and probable cause is just an officer's reasonable suspicion that a person may be involved in a crime. The easiest way to illustrate this is it's late at night, an officer sees you driving along the road, and the officer observes you're swerving, left or right, you're having trouble maintaining your lane. Perhaps you speed up for no reason, you slam on your brakes for no reason, things like this. Is this probable cause for the officer to stop you? Is this a reasonable suspicion that a person may be involved in a crime? Yes. What is the crime that the officer may believe is being committed? Driving while intoxicated. So if the officer observes something like that, there's a reasonable suspicion a crime is being committed, they can stop you. They don't need, in that instance, they don't need to get a search warrant. They don't need an arrest warrant. Who decides if probable cause is valid? Who makes this choice? The courts do. If the courts decide that yes, the officer had reasonable or had legal probable cause, we can move on. But what if the courts decide that no, the officer really didn't have probable cause? Well, if this is the case, we see the creation, or we see something come into play called the Exclusionary Rule. Sometimes it's also referred to as fruit from the poisonous tree. All this means is that any evidence obtained during an illegal search cannot be used at trial. Any evidence obtained during an illegal search cannot be used at trial. We see this first come into effect, or first come into being, in the court case Mapp versus Ohio, 1961. This is Miss Dalry Mapp. What happens is police officers in a Cleveland, Ohio suburb received information that a suspect in a bombing case, as well as some illegal betting equipment, might be found in the home of Dalry Mapp. 3 officers went to the home and asked for permission to enter, but Miss Mapp refused to admit them without a search warrant. 2 officers leave, 1 stays behind. 3 hours later, the 2 officers returned with several other officers. Brandishing a piece of paper, they broke in the door. Miss Mapp asked to see the warrant and took it from an officer, putting it in her dress. The officer struggled with Miss Mapp and took the piece of paper away from her. Based on her actions, they handcuffed her for being belligerent. They didn't find the bombing suspect. They didn't find any gambling equipment. However, they did find child pornographic material in a suitcase next to her bed. She was arrested, prosecuted, and found guilty for possession of child pornographic material. Now, in this case, what the prosecuting attorney, what the government presented as evidence was the pornographic material. What they did not present was the warrant. The argument here that was made at the trial level and continued on, Ms. Mapp's attorney is saying, look, they did not have a warrant. If they had a warrant, they would have presented this as evidence. They didn't have a warrant. It was an illegal search. So, due to the exclusionary rule, this fruit from the poisonous tree, it was an illegal search. The child pornography should not have been allowed in as evidence. The trial court disagreed and allowed it in. The appellate court upheld the lower court's decision. What did the Supreme Court say when they got this case? Was this a violation of Ms. Mapp's Fourth Amendment right against search and seizure? Yes. In a 6-3 decision, they ruled that the police, they had time to go get a warrant. They just chose not to. Since they had time, they had no reasonable suspicion that a crime was being committed. They shouldn't have gone in the house. So, Ms. Mapp's conviction was overturned. She won. Fifth Amendment. Fifth Amendment's going to cover a number of items. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury. A grand jury, this is pre-trial. This grand jury action is going to occur before the alleged criminal goes to trial. The grand jury, this is simply a jury that determines if sufficient evidence is available to justify a trial. The prosecuting attorney will go in and they will say, I believe Joe Blow committed a crime. This is my evidence. If he can convince a certain percent of the grand jury that, yeah, there's a reasonable suspicion, we need further investigation, we need a formal trial, the grand jury will then issue an indictment. The indictment is the formal charge. This is going to be the start of the trial process. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Told you Fifth Amendment was a lot. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. We call this double jeopardy. The simple but incomplete definition of double jeopardy is you cannot be tried twice for the same crime. Now, like I said, it's a good definition, but it's just a little incomplete. There needs to be something else added to it. You cannot be tried twice for the same crime in the same court system or in the same judicial system. How many judicial systems do we have in the United States? We have 51. 50 state judicial systems, one federal judicial and one federal court system. You cannot be tried twice for the same crime in one system, but you can be tried twice if one is in each system. For example, we are in Texas. If you go into a post office and you murder somebody, is this a federal crime? Yes, it is. It's a federal crime. The federal government has a statute. You can't kill people. It is a federal crime because it occurred on federal property. But is it also a state crime, even though it occurred on federal property? Yes, this is still a crime in Texas. You cannot murder somebody legally in Texas. So if the federal government got this person, they prosecuted them, they were not able to get a conviction. The person was convicted. Then Texas could come behind, try this person for murder, but it is not double jeopardy because we are trying it in a state judicial system and not the federal judicial system. So two different court systems. That is perfectly legal. Let's look at some cases. Palco versus Connecticut, 1937. In 1935, Frank Palca, his name was actually misspelled as Palco in court documents, a Connecticut resident, broke into a local music store and stole a phonograph, stole a record player. He proceeded to flee on foot. When cornered by law enforcement, he killed 2 police officers and made his escape. Mr. Palco was apprehended. He was captured about a month later. Now, Mr. Palco was charged with first-degree murder. However, he was convicted of the lesser offense, of a lower offense of second-degree murder, and he was sentenced to life in prison. The prosecutors appealed per Connecticut law. They did not like that he was not convicted of first-degree murder. So they appealed and they won a new trial. They tried Mr. Palco again for first-degree murder. This time he is convicted. This time he is sentenced to death. Mr. Palco appeals, arguing that the Fifth Amendment protection against double jeopardy, this applies to state governments through the Due Process Clause of the 14th Amendment. The court's decision. Is this a violation of double jeopardy? In an 8-1 decision, the court decided no, this was not a violation. Justice Cardozo stated that the Due Process Clause protected only those rights that were of the very essence of a scheme of ordered liberty, and that the court should therefore gradually incorporate the Bill of Rights onto the states as justiciable as judicial violations arose based on whether the infringed right met that test. So what this means is they took these rights and applied them on a subjective case-by-case approach. And they decided that Mr. Palco's conviction, on the basis that was upheld, it was legal, on the basis that this double jeopardy appeal was not essential to a fundamental scheme of ordered liberty. So what they decided was, because they did the selective incorporation, and we talked about that in the first section. They decided that this was double jeopardy was not a necessary right to have in a scheme of ordered liberty, so they weren't going to give it to him. Mr. Palco was executed in Connecticut's electric chair in 1938. Now, we're going to revisit double jeopardy in a case called Benton versus Maryland. In Benton versus Maryland, John Benton was tried on charges of larceny and burglary. He was acquitted of larceny, but convicted of burglary and was sentenced to 10 years in prison. Shortly after Mr. Benton's conviction, the Maryland Court of Appeals ruled in a different case that the portion of the Maryland Constitution that required all jurors to swear their belief in the existence of God was in itself unconstitutional. Since the jurors in Benton's case had been selected under the unconstitutional provision, he was given the option of demanding a new trial. Why would having to swear in the belief of God be unconstitutional? First Amendment, freedom of religion, Establishment Clause, wall of separation. Remember that? Okay. So, Mr. Benton is given the option of demanding a new trial, and he says, I'm already sitting here in prison, so why not? So, Mr. Benton did in fact choose to undergo a new trial. At the second trial, the state charged Benton with larceny. They charged him with burglary. What do you think happened in the second trial? He was convicted of both this time. Mr. Benton says, hey, wait a second. You can't try me again for larceny. You tried me once and I was acquitted. You cannot try me again. This is a violation of Fifth Amendment and right against double jeopardy. Maryland's saying, hey, you wanted a new trial. We gave you a completely new trial. We gave you what you wanted. Was this an example of double jeopardy? In this case, in a 6-2 decision, the court decides, yes, this was a violation of the double jeopardy, Fifth Amendment. Mr. Benton could not be tried again for larceny because he had already been acquitted once. At this point, I'm going to ask you, one body can overrule a Supreme Court decision. Who is it? Who is the only body in government that can overrule a Supreme Court decision? The answer, the Supreme Court. The Supreme Court is the only body that can overrule themselves. They can change their minds at a later date. They are not bound by precedent. They can set new precedent. I mean, if we look right here, Palco versus Connecticut, they made one decision. Benton versus Maryland, they overruled themselves. They made a second decision. So the Supreme Court is the only one who can do this. Fifth Amendment continued. Self-incrimination. No person shall be compelled in any criminal case to be a witness against himself. So this self-incrimination came out of a case, Miranda versus Arizona, decided in 1966. This is Mr. Ernesto Miranda. On March 13th of 1963, Ernesto Miranda is arrested by the Phoenix Police Department based on circumstantial evidence linking him to the kidnapping and rape of a 17-year-old girl 10 days earlier. After 2 hours of interrogation by police officers, Miranda signed a confession to the rape charge on forms that included the type statement that says, I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. However, at no time was Mr. Miranda told of his right to counsel, and he was not advised of his right to remain silent or that his statements would be used against him during the interrogation before being presented with the form on which he was asked to write out the confession that he had already given orally. At trial, when prosecutors offered Mr. Miranda's written confession as evidence, his court-appointed lawyer objected because the objected that because of these facts, the confession was not truly voluntarily given. It should be excluded because he was not told he didn't have to do this. It was not a voluntary action. The court overruled his objection, and based on his confession and other evidence, Mr. Miranda was convicted of rape and kidnapping and sentenced to 20 to 30 years imprisonment on each charge. Mr. Miranda's attorney filed an appeal with the Arizona Supreme Court, claiming that Miranda's confession was not voluntary and should not have been admitted into the court proceedings. The Arizona Supreme Court agrees with the trial court. So we jump to the federal level. We go to the Supreme Court. What did the Supreme Court decide? By not telling Mr. Miranda these facts, that he didn't have to talk to him, he didn't have to sign this confession, that he had the right to an attorney. Did they violate Mr. Miranda's rights against self-incrimination? In a 5-4 decision, the Supreme Court said, yes, they did violate his rights. They had to make him aware that he had these rights before they could talk to him, before he had to sign anything. They had to tell him he didn't have to. Now, in my mind, the strongest branch, the most powerful branch of the government now is the judicial branch. Why is that? Think about when the Supreme Court makes a decision. Who does it affect? Everybody in the United States. How long? Until they say otherwise. If we look at Miranda versus Arizona, we see the creation of the Miranda warning. You know, we have heard this on TV, maybe had it read to us. You never know. I don't know. I'm not judging. But we all know this. We have the right to remain silent. Anything you say can be held against you. You have the right to an attorney of your choice. If you cannot afford a lawyer, one will be provided without charge. Now, this is where I'm going to go back and just what I said a second ago about power. The court decided in 1966 that the Miranda warning needed to be given when somebody was arrested. Is this decision still in effect? Yes, it is. Over 50 years later, when a person is arrested, they have to be read their Miranda rights. Who has to do it? Every law enforcement agency in the United States has to give this Miranda warning. Sixth Amendment, speedy and public trial. We're finally into the Sixth Amendment, guys. We're getting there. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Speedy trial, got to occur quickly. How fast? What is a speedy trial? We're not sure because we see courts are reluctant to set timetables for trials. Why is this? Well, because each trial is different. Sometimes you have to have, some sort of test, scientific test done. How long is it going to take the lab to complete the test? Sometimes there's a number of witnesses that you need to interview to build your case. We don't know, but we want to make sure that everybody, both sides, both the defendant and the plaintiff, the government, have enough time to gather all the evidence and provide the necessary evidence to prove guilt or innocence. So we do have these speedy trial laws, but we can't define them. Sixth Amendment guarantees us the right to a public trial. What this means is that the public and the press cannot typically be kept out of the courtroom. Is this good or bad? Both or neither? It's actually both. We need the ability to go in and observe criminal trials to make sure that all the rights we are guaranteed are being observed. What happens if on Monday the court comes out and says John Doe was convicted of burglary, he was sentenced to 10 years in prison? We're the government, trust us. On Tuesday, they come out and say Jane Smith was convicted of possession with intent to deliver and sentenced to 10 years in prison. Trust us, we're the government. On day 3, the government comes out and says Ronald McDonald was accused of selling horrible food and sentenced to 20 years in prison. We're the government, trust us. Do you see anything wrong with that? What happens when one day the government comes out and says, you, place your name in this blank, you have been convicted of a crime and sentenced to X number of years in prison? We're the government. Trust us. If we don't have the ability to go in, if these trials aren't public, are we sure that the alleged criminal are getting all their rights and their rights aren't being violated? No. So public trial is very, very important. Now, having the press in the trial, the press cannot typically be kept out of the courtroom. This can be good, this can be bad. If you remember a case a few years ago, well, more than a few years ago, but the case was out of Florida. It was a young lady named Casey Anthony. She was accused of murdering her young daughter. This was in the media for about a year. The press ran stories, and they convicted her. The press convicted her in the media. Well, are trials decided, is guilt or innocence decided in the media, or are they decided in the courtroom? It's decided in the courtroom. While the press said she was guilty, the jury said she wasn't. That the prosecutors did not do a good enough job proving guilt beyond a reasonable doubt, so they acquitted her. So she walks out a free person. But what is she walking into? For a year, the press has been giving this narrative that she's a murderer, she's a horrible person, she killed her daughter. She walked out into her life being a living nightmare. So, was this good or was this bad? It was bad. She was acquitted. The jury decided that the prosecution had not done their job, and yet she was still punished, even though she did not commit a crime according to the jury. Still, Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. This means that you have the right to a trial by jury, a jury of your peers. Does this mean that the demographics of the jury must match you exactly? No. What this means is that the jury must be a cross-section of the community. That's all it means. The jury must be a cross-section of the community. To make sure this is a legitimate section, that this is a legitimate representation of your community, jurors cannot be excluded because of their race, their religion, their gender, their age, that kind of thing. It must be a true cross-section. continued, have the assistance of counsel for his defense. See, yeah, I like this better. Here we go. I like this slide much better. The state provides this Sixth Amendment right to an attorney, says that the states provide attorneys for those who cannot afford, for those who are too poor to afford one for themselves. Now, they can't just put any attorney in there. The attorney must be competent. The attorney must actually know what they are doing. This comes up from a case called Gideon versus Wainwright. This is Clarence Earl Gideon. What happens? The facts and the prior history. Between midnight and 8 a.m. on June 3, 1961, a burglary occurs at the Bay Harbor Pool Room in Panama City, Florida. Someone broke a door, smashed a cigarette machine and a record player, stole money from the register. Later that day, a witness reports that he had seen Clarence Earl Gideon in the pool room at around 5:30 that morning, leaving with a wine bottle and money in his pockets. Based on this accusation alone, the police arrested him and charged him with breaking and entering with intent to commit petty larceny. Mr. Gideon appears in court and says he was too poor to afford counsel, whereas the following conversation took place between Mr. Gideon and the judge. Once Mr. Gideon says, I'm too poor, I can't afford counsel, Sixth Amendment says the state has to provide counsel for me. The judge says, Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I am sorry, but I will have to deny your request to appoint counsel to defend you in this case. Mr. Gideon once again reiterates, the United States Supreme Court says I'm entitled to be represented by counsel. You go into court, you argue with the judge, who's going to win? You or the judge? The judge is. So Mr. Gideon was forced to act as his own counsel, try to conduct a defense. He was unsuccessful. The jury returns a guilty verdict, and they sentence him to 5 years in the state prison. Well, while in prison, Mr. Gideon actually appeals to the Supreme Court. Handwritten note to the Supreme Court that says, I was denied counsel, and therefore my Sixth Amendment right, as applied to the states by the 14th Amendment, this has been violated. Based on this handwritten note, the Supreme Court accepted his case, and the court assigned him a very prominent Washington, D.C. attorney who happened to, later on in his career, become a future Supreme Court justice. But, they said this was a violation of Mr. Gideon's Sixth Amendment right to an attorney. If they are destitute, if they are too poor to afford an attorney, the court has to appoint one regardless of what the charge is how serious the charge is, whatever it is. Last amendment under criminal justice, Eighth Amendment, cruel and unusual punishment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That is a picture of jail food, and that is all I'm sure it is. I couldn't tell you. It looks like a loaf of some sort, but I'm not going to swear to that. Let's focus on the cruel and unusual punishment. What is the harshest punishment that the government can impose? Death. The harshest punishment that we can impose is the death penalty. Do we use it? Yes, we do. Going to start off in 1972 with a case called Furman versus Georgia. Furman versus Georgia is actually a culmination. It is actually 3 cases rolled into one and discussing how the death penalty is applied. In Furman versus Georgia, Mr. Furman is committing robbery. He is robbing a house in the middle of the night. In the process, his initial story, his first story is, yes, I'm robbing the house. In the process of robbing the house, the owner wakes up. I run out of the house. The owner is chasing me. I have a weapon. I have a pistol. I turn around and just fire blindly to stop the owner from following me. And without meaning to, it was unintentional, I hit and kill the homeowner. That's his initial story. At trial, the story changes. It says, yes, I robbed the house. I woke up the homeowner. He chased me. While trying to escape, I tripped and I fell, and the firearm accidentally went off, hitting and killing the homeowner. Either way, it didn't matter because the homeowner was killed in the commission of another felony. This made it a capital crime. This meant that Mr. Furman was eligible to receive the death penalty. And he does. Now, there's another case going on at this time. Jackson versus Georgia. Jackson was convicted. He attempted to commit armed robbery, but he also committed rape in the process. So he didn't kill somebody, but he did commit rape. Committed armed robbery and he committed rape. So in Jackson versus Georgia, Mr. Jackson is convicted of rape, committed armed robbery. He raped a female. He was sentenced to death. Third case is Branch versus Texas. Mr. Branch also rapes a woman and is convicted of rape. Now, we have murder, we have armed robbery and rape, and then we have rape. But 2 things are going to be of a concern here. First off, every defendant, all 3 defendants, were African American males. Now, each charge, murder, armed robbery, and rape, and then rape, each charge is bad, but are they equal? Should they be equal in punishment? The argument here that is being made in this case is that they shouldn't be. These crimes, while bad, have different levels of severity, and they don't all deserve the death penalty. The only reason that the death penalty is being applied in all 3 cases is because in each case the defendant is an African American male. This is their argument. In a 5-4 decision, the Supreme Court agrees. They say the death penalty as it is currently being applied, is unconstitutional because it is being applied more often, more harshly, to minorities. So we see the Supreme Court place a moratorium, place a temporary halt on the death penalty. They tell the states, we're not going to rule it unconstitutional, but if you want to use it, you need to rewrite your laws to make sure it is applied equally to all defendants. So a number of the states decide that they want to continue to use the death penalty, so they do rewrite their laws. 1976, the Supreme Court says, okay, for the states that want to continue to use the death penalty, we've looked over your laws, we're lifting our moratorium, now you can start issuing the death penalty again as a possible sentence. Well, this does not sit well with a number of people, and this is going to lead us to our next case, Gregg versus Georgia. I told you Furman was 3 cases. Gregg is a culmination of 5 cases. These are cases out of Georgia, Florida, Texas, North Carolina, Louisiana. Now they've already amended their statutes. They've changed their death penalty statutes to meet these guidelines. So the states are good to go to use them. Well, these attorneys decide, we want the death penalty declared unconstitutional, period. We want it said that this is a violation of 8th Amendment cruel and unusual punishment. Were they successful? Well, do we still have the death penalty today? Yeah, we do. What the court says. The death penalty is constitutional. The court found that the death penalty, and this is out of their opinion, and this quotation, comports with the basic concept of human dignity at the core of the 8th Amendment. The death penalty serves 2 principal social purposes, retribution and deterrence. In part, capital punishment is an expression of society's moral outrage at particularly offensive conduct. But this outrage must be expressed in an ordered fashion. It is retribution, and retribution is consistent with human dignity because society believes that certain crimes are themselves so grievous an affront to humanity that the only adequate response may be the penalty of death. So what they are saying is that, yes, the death penalty is proper, it is constitutional. There are some crimes out there that are so bad that sometimes the only proper punishment is the death penalty. So, yep, death penalty by itself is not unconstitutional.